Well, I'm glad to see nothing has untoward has happened to anyone who was in the court before, and can't smell burning, so I think we're all right. Mr. Firth, I think we stopped at about 2:10, so we've lost an hour and 5 minutes. Please do continue.
Thank you. I'll bear that in mind and try and pick up the pace where possible. I was just finishing off showing you propositions 2 and 4 from paragraph 95.
2 and 4?
Yes.
Yes.
So, must be demonstrated the agreement affects actual potential competition to such an extent negative effects on prices, output, innovation, or variety or quality. The point being those are all effects in the market. And then proposition 4.
That's the counterfactual.
Exactly. I mean, my submission is that's the only way you can sensibly consider whether there's a distortion of competition, is to consider what the position would be in the market without the benefit, so with and without taxation. In turn, what that means is it's necessary to consider decisions that will or might be taken by both the trust or the trusts and actual or potential competitors. You do have to consider what they will or might decide to do, because that's the only way you can consider the effect in the market. By way of demonstration of that approach, whether they said they were applying it or not, in terms of specifically applying the TFEU Article 101 case law, that's exactly what happened in the Isle of Wight case upon its return. And we can see a summary of what is otherwise called a long decision in the FTT in the Court of Appeal decision. That's at page 303 in the authorities. Sorry, it's my 303, your page 301. Which is in your first volume.
Sorry, are we looking at the Court of Appeal decision?
This is the Court of Appeal, but on paragraph 14 they summarise what the FTT did, and I'm just going to rely on the summary of that. Paragraph 14, you get a sense of the size of the hearing, 7 days, 9 witnesses, some witnesses of fact, some experts. At 15, the FTT rejected HMRC's submission that there is a presumption of law that differential tax treatment will distort competition. 16, the First Tier Tribunal said that the question is not how the local authorities might respond to a change in the VAT treatment, but rather had to make a comparison between, on the one hand, a world where local authorities are treated as taxable persons, and on the other hand, a world where they are not, which, to my mind, is the counterfactual we've just seen described. There's then further description of the FTT decision. If I can skip forward, please, to 21, just so you can get an overall sense. I mean, please do read it if you're interested in the rest of it. But 21, the FTT set out extensively its findings of relevant primary fact about the market, the evidence it received, about the local position in Birmingham, Isle of Wight, Tyneside, and a number of other areas. Also set up the evidence given on behalf of HMRC. 23, common ground before the FTT that the burden was on HMRC to establish that the non-taxation would cause a distortion. 32. We can start to see the FTT's findings, which was there would be a combination of upward and downward pressures on price.
And 33 shows that they're still looking at what might be over time the effect on differential prices.
Yes, yes. And at 38 you can see the conclusion as to the quantum of the distortion, the degree of distortion. The Court of Appeal dismissed the appeal, but we can see, if we may, on page 308, paragraph 64, the Court of Appeal recognises that at the heart of the FTT's decision was the conclusion in the hypothetical world, so we're considering a hypothetical world, in which VAT had never been imposed, those charges would have been lower. That conclusion was based on two principal matters, and the Court of Appeal upholds the decision on those matters. All I'm illustrating is that this is exactly the sort of counterfactual exercise that is, in my submission, necessary. You need to establish what position otherwise would pertain in the market. It would be very surprising in my submission if all three levels of judiciary failed to identify that, in fact, this exercise was wholly unnecessary, because all HMRC need do is point out that prices might be lower or profits might be higher. So in my submission, this is consistent with principle that I've sought to rely on from the Article 101 case. The third element of this proposition was that distortion of competition carve-out is there to ensure that private operators are not placed at a disadvantage because they are taxed and public authorities are not. I think I've shown you that in the authorities already, so I don't think it's in dispute. So those are the three sub-propositions. And as I say at paragraph 68 of my supplementary skeleton, what they mean for a case like this is that HMRC would need to establish what would pertain on the market at an overall national level if hospital car parking was not subject to VAT.
There's a sort of a logic tree to how that would operate, isn't there? So you first of all say, if tax is not payable, would charges go down? Because they wouldn't necessarily. And the principals control the extent to which pricing can be just chosen at will. And you say, if they're going to go down, by how much? Because it could be anything between 0 and 20. Then you say, would that affect either actual or potential competition? So let's assume the starting rate is £1 an hour and it goes down to 80p an hour. Would that affect new entry into the market or expansion by rival car park service providers? Would they be investing because it's gone down from £1 to 80p an hour? Then in actual competition, you've got to say if it goes down, would that cause rivals to lower their prices and therefore their profits? Or would they lose custom because of switching to 80p an hour instead of £1 an hour?
Yeah.
In circumstances where the car park is primarily dedicated to people using a hospital, so the capacity may be very slight. As we just work through it logically,
Yes.
You would then come to the conclusion, would this significantly affect competition?
Yes.
I mean, it's a fairly remote proposition.
Yes. I entirely agree that, yeah, you've got to decide, would they, as my lord said, would they lower prices, and if so, what would the effect of that?
Well, and by how much?
By how much?
Because you may want to retain some of that profit to go into the NHS purposes. So instead of 20%, you may just reduce them by 5 or 7.
And
if it's £1, then that means you're knocking 5p off or 7p off.
And if the vast majority of these car parks are adjacent to hospitals and not much else,
yeah,
it doesn't really matter how much how much it goes down by. You're not going to sort of really increase your customs or potentially take away from others. So that's one side of the tree, my lord. And the other side is, well, let's say they don't lower their prices, so they have higher profits. Well, how does that affect competition? What does that change in the market?
That doesn't prevent any switching. So nobody's going to switch to that hospital because it hasn't changed its price.
No. I mean, that's my proposition, is that higher profits doesn't of itself affect or have an effect in the market. And that's particularly so in a case like this, where the purpose is, this is an income generation activity, to have more funds to spend on healthcare. So if you just take the extra profit, your extra 20p in the pound, and spend it on healthcare, my submission is I cannot possibly see how that has an effect in the market or leads to a distortion of competition.
Is there a discussion of that in the Isle of Wight cases, about the profit going into the general fund of the authority, and a question about whether they make more profit, and that was considered to be a distortion?
I would need to check that, my lady.
It could only be a distortion if that extra money going into the NHS was then used to create more car parks.
Well, one would have thought so.
Yes,
Yeah.
well that was
Otherwise it can't impact on the car park.
that was my submission to the Upper Tribunal as well. Potentially, if they were using the profit to sort of gain leverage in the car parking market, then potentially, but it's not.
If it goes to scanners.
Yeah, well, exactly. I would need to check, my lady, if they deal with that. I know that their main conclusion was prices would go down by a significant amount, and that was a distortion. But I don't want to finally answer that until I've.
Thank you.
But even if they do go down, that doesn't tell you anything about competition unless you know how that impacts upon competitors,
Yes.
actual or potential.
Yes.
As you said, I mean, if it's a countryside hospital
Yes.
and you're competing with someone 5 miles away in the city centre, it's a complete irrelevance that the price goes
Yeah.
down. There's
Okay.
got to be switching.
Now, of course, we have to look at this at a sort of overall national level. But
Yes.
we take into account the sort of, you'd have to do that exercise taking into account the estates of the various hospitals. Are they prime city centre real estate that could be used? I mean, the most we know, and all HMRC, as far as I'm aware, could rely on was, well, there was an instance where it was somewhat near an airport, and they were getting some people using their car park instead of the airport car parks, but then they took action to stop it. Which is my point, that well, they wouldn't reduce their prices below the national levels. You've seen that in the guidance itself, saying, well, these are what we've established as the sort of benchmarks, and there is a specific explanation that you may need to look at your prices again if you find that's happening, and in that case it did happen.
You'd also have to have evidence as the extent to which drivers shopped around.
Yes.
In other words, was there any price sensitivity? Because the difference between
Yes.
10 pence or 20 pence an hour,
Yes.
nobody might care about that in the context of a visit which is only a stay which is 2 or 3 hours, 50, 60p's difference.
Which is why airport car parking might be a bit
Might
of a
be
unique
different, yeah.
situation.
Yeah. People who go to hospitals often stay there longer than just a shopping trip. They may do. They may be there for a day or half a day,
Yes.
or whatever.
Yes. But,
All one can say is it's a factual analysis.
Exactly, and it's not something you can determine with sort of abstract reasoning and just saying, well, one of these things must happen, and therefore we have a distortion of competition. That, with respect to my criticism of both the FTT and the Upper Tribunal. That really is my 12th proposition, that distortion of competition requires evidence and analysis. It's not to be presumed, and I would add, cannot be identified by abstract reasoning. And I refer there to the National Roads Authority case. In the interest of time, I might not take you to that case. I might just give you the references. It begins on page 904. But what we see at various points, at paragraphs, I think it's 40, 41 and 43, is clear recognition that we need to do an economic assessment of the circumstances. And at 44, I quote this, paragraph 76 of my skeleton, the court specifically rejects an argument that the mere presence of private operators in the market means that there must be competition. or a significant distortion of competition. That's specifically rejected, that sort of presumption. Which leaves us with the requirement to carry out the sort of analysis I've been submitting as necessary. I also deal here, in paragraph 78, with the so-called general rule that HMRC rely on, which the Upper Tribunal refers to. Judge Sinfield appears to have adopted in both this case in the FTT and the Loughborough decision in the Upper Tribunal. In my submission, that's a misapplication of what was being said in rank. So maybe I do just show you this point, because I think this is a key point HMRC rely on, some sort of assumption or general rule.
So you're taking us to rank?
Yes, this is the Court of Justice in rank. It begins on page 861, which must be your
Third one.
third volume, I would say.
Yes.
The scenario, we can see at paragraph 13 and 15, was that we had slot machines, and the complaint was that different slot machines are being treated differently for VAT purposes, even though they're similar and in competition with each other. That's at 13 and 15. The reference to the general rule is at paragraph 35. On page 878. There's 2 points I make in relation to that. The first is that the Court of Justice says suppliers which meet the same needs, and that has a meaning, which we'll see in a moment. And the second is this is said in relation to a case where we're dealing with slot machines and private operators. The court did not have in mind situations where you've got a public authority who may well be using any additional profit to fund non-commercial public authority activities. So this may be a general rule that holds good where they do meet the same needs and where you're looking at a private operator. Because if that private operator can simply undercut other private operators by 20%, then you can see how that might offer a distortion. In relation to...
Sorry, this isn't about the... Is this about the exemption or not?
This is about exemptions from VAT for in relation to gambling and different slot machines being treated differently.
Right, so it's because provision we're looking at starts with, in a sense, a presumption that there will be tax. You're then saying there won't be tax if there's no distortion of competition. It doesn't say if it creates lack of fiscal neutrality.
Yes. I mean, the distortion of competition is an aspect of fiscal neutrality, but yes, it doesn't proceed through the same reasoning steps. But actually, when you read it in context and understand what meets the same needs is, and when you put it in context of, well, the CJU's looking at private operators acting in a fully commercial context, then it just doesn't translate to a situation where we've got public authorities. Just on the meaning of meeting the same need, can I refer you to 44, please? Paragraph 44 on page 8. It has never been demonstrated that hospital car parking has no significant, the fact that it's a hospital car park has no significant influence on the decision of the average consumer. Just thinking about the point in general terms, the fact that the car park is adjacent to a hospital or a health facility, and we don't know whether it's adjacent to anything else, means that, yes, hospital users will want to use it, but we don't know that anyone else wants to use it or would regard it as similar. And in relation to car parking, as I say at 79, the location of the car park plainly would be expected to have a significant influence. So just to, in a nutshell, in order for this general rule to apply, it would need to be shown that these are car parks, or the NHS Trust car parks, meet the same needs as consumers of other private car park operators. And you can't do that, certainly not on an abstract a priori basis, because clearly the location of the car park will have a significant influence on the decision of a consumer. So we don't actually satisfy the basic test of meet the same needs. It's never been demonstrated in this case. My second point is the one I've already made, which is that you cannot extract that general rule where the Court of Justice states it in relation to private operators making commercial profits and having no sort of public interest activities, and apply it to public authorities where the money generated may well be intended to use, and we know in this case is intended to be used to fund wider public authority activities. And that goes back to the decision tree my lord refers to, that you've got to work out what would happen at each stage. So this general rule actually doesn't help you in relation to our situation, my submission.
This would apply if you had two private car park operators, one of whom was exempt from tax and the other wasn't. Then it might, neither of whom was subject to public law obligations.
Yeah.
Then it would make sense.
Even then, if their car parks are in different locations, and so the non-taxation of one couldn't have a significant influence on whether to choose that car park or that car park, even then you wouldn't actually be within the scope of the rank rule. It's actually narrower than it might first appear when you read it properly with what the same needs means.
Yes.
So
it may be that's encapsulated in the expression as a general rule
Yes.
in paragraph 35.
yes,
I mean, it's a reasonable starting point that if you've got two commercial operators not subject to public law obligations, both supplying the market as a whole, and you exempt one category from tax across the entire country,
yes,
is a reasonable starting point
yes.
that they are benefited against their competitors in terms
Particularly
of competition.
because this is dealing with slot machines, and so you can have two people offering to send to you a slot machine, and so your geographical location is irrelevant. One saying, well, you won't have to charge VAT on
Yeah.
your slot
Yeah,
machine
yeah.
suppliers, and the other one saying you will. Well, which one are you going to choose? Well, you can see that you might well choose, probably would choose the non-taxation one. But that's a sort of a fungible good where it's completely interchangeable, as long as it meets the same needs and the differences wouldn't have a significant influence. It makes sense there as a starting point, as my lord said. You cannot pick that out and translate it to car parking, where the location clearly has a significant influence, and where we're dealing with public authorities in any event. That's my submission.
That's right. That's why the rubric for the test is important. It's someone who is governed by public law acting as such in the provision of the commercial
Yes.
service.
Yes.
Then they still don't get away with it unless there's no distortion of competition.
Yes, and that goes back, I suggest, to what I said or submitted about the purpose of the exemption in Article 13, which would appear to be to generate more income or allow public authorities to keep more of the income they're able to generate from these sort of incidental activities. So the fact that you get more money from it as a public authority and you spend it on other public goods is probably what it's aimed at.
I'm sure you'd have shown us if it was relevant. Is there anything in the recitals to the relevant EU directive which provides any guidance?
No, the recitals confirm that the general principle against distortions of competition, but I couldn't find anything that sort of specifically helps you on Article 13. And maybe more surprising, I couldn't find anything in any of the CJU cases telling you what the purpose is, which is why I've had to sort of try and work it through from first principles. That is surprising, but well, you have my submission, I won't repeat it. My final proposition is simply that the required distortion relates to private operators participating in the market, potentially participating in the market, alongside the authority, not instead of it. I mean, that's not actually relevant because there's no finding that it would distort that decision as to whether to subcontract or to do it yourself. But nevertheless, for completeness, I do submit that that's not the right test. And in fact, I think I've already shown you this in the motorway toll cases. There was a submission from the Commission that it should be essentially limited to things you couldn't subcontract out, and the Court of Justice rejected that.
And the guidelines assume you can. The principles assume you can subcontract because it talks.
Oh no,
make
actually
sure
you can. Yes, I'm not. Sorry, there's two separate things. One is, could an NHS Trust subcontract out the car parking? It could. The second question is, well, would a distortion of your decision as to whether or not to subcontract out caused by non-taxation if you supply it? Because if you subcontract it out, the subcontractor doesn't benefit from exemption. So could that, if that choice is distorted to a significant amount, etc., does that invoke the carve-out? My submission is no, because it's not concerned with the decision whether to contract out or not. It's concerned with distortion of competition as between you and people who compete alongside you or might compete alongside you.
Sorry, it's not relevant, but the assumption that this wouldn't apply if you subcontracted it might depend on how you subcontracted it. If there's a pure agency arrangement for, a third party to operate the app or something like that. I know we're not deciding this, but I just wanted to clarify what is being
There are cases
said.
which I haven't shown you because I didn't think they were relevant, where, for example, the service of tax collection is subcontracted out to a private party, and although that's obviously something that tax collection is obviously something that exercises public powers, the fact that it's carried out by a non-public body means it cannot fall within Article 13. So there is a very clear carve-out that if the person doing it is not a public body, even if it's something a public body would do, relies on public body.
I understand that. That's not quite my question, but I don't think. Is it, for the purposes of this appeal, we are not looking at a subcontracting position, I take it? And that's that, so we don't really need to explore it.
We don't, my lady. And if you were to subcontract, you don't have to carry the VAT analysis of, well, you used agency, is that a supply to you?
Yes,
yeah,
exactly.
It gets quite complicated, as my lady will know. But no, we're not dealing with that. I was just making the point that that decision is not the decision we're looking at in my submission. And I say, well, that's made clear from the authorities, in particular the motorway toll cases where they said they rejected a submission that should be limited to things you can't delegate. With that in mind, I propose to show you now the Upper Tribunal, the first tier tribunal decisions on this issue, and then set out briefly my respectful criticisms. The FTT decision, that's core bundles have 11. Page 127, could I ask you to read, please, paragraph 65? 65, my lord. I have two observations on that paragraph, which are probably obvious from what I said previously. 4 lines up on page 127, First Tier Tribunal says it's to my mind obvious that if the trust is not required to charge, it could undercut commercial car park operators by providing parking more cheaply, whether it chooses to reduce its charges by an amount equal to the VAT or to pocket the additional income is nothing to the point. And from my submissions, you'll know that's exactly part of the point. In fact, even that's, you have to decide what would happen and then work out whether it would be a distortion. So to say it's nothing to the point is, with respect, wrong. And the First Tier Tribunal goes on to say, well, in both cases, there would be a distortion of competition, either because the cost of parking would be cheaper or the profit would be higher. But that actually is a very incomplete analysis. Even for the cost being lower, as I said to my lord, you still need, and my lord said to me, you need to go through the decision tree to say, right, your car parking's cheaper. How does that affect your competitors?
You've got to look at switching.
Exactly.
Risk of switching.
You do that at a national level, but you still have to do it. And then you can see that the First Tier Tribunal says in terms that higher profit is a distortion of competition, which it plainly isn't by itself in my submission. It may, with further analysis and investigation of what would happen, lead you to conclude that there could be a distortion of competition because that profit's being used to sort of edge out competitors, etc., etc. But the higher profit of itself is not a distortion of competition. It's not an effect in the market. And no, the tribunal doesn't actually decide what would happen. It just decides, well, one of these things must happen, and they're both distortions of competition. And you'll know from my skeleton that I submit that's an impossible test, because if both of those things are distortions of competition, and one of them must happen, then there's always going to be a distortion of competition. The Upper Tribunal upholds this decision. If we could go, please, to that. It's line 6 in the court handle. And beginning at paragraph 98, please. So they first begin by rejecting my test that there must be an effect in the market. They say, well, that may well be what they were assessing island-wide, but that doesn't mean it's a necessary test. It's not an exhaustive test, is the point they make. At 99 to 103, they reject HMRC's argument that the possibility of a distortion is enough. They emphasize it says would, and I don't think there's any challenge to that. At 104, the Upper Tribunal reasons that the FTT applied the correct test because it asked whether there was a significant distortion of competition. That fails to consider whether it got the test for distortion of competition right. It's not a situation where the test obviously means what it says with no further elaboration. You can see that from the cases I referred to, particularly in 101, the Article 101 cases. Just by analogy, that would be like saying, well, the tribunal applied the right test for whether it's acting as a public authority simply by saying we decided it was acting as a public authority without considering the myriad principles we get from the case law. So the tribunal did need to go behind and try and work out what had happened. 105 is my criticism of the failure of the fact that additional income was itself treated as distorting competition. You can see in the final sentence I said something more is needed, such as the evidence that higher profits would lead to expansion of their activity to the disadvantage of private operators. But 106, they reject that criticism. They refer to rank, which I've already dealt with, and basically it starts from the proposition that, well, the very fact that there's actual competition and these some suppliers are not taxable means there's a distortion of competition. But that actually doesn't answer my question as to my submission as to why is, asking rhetorically, why is a higher profit a distortion of competition? There's actually no explanation anywhere in 106, 107 or anywhere as to why it's a distortion of competition. What is the distortion?
In an ordinary market, it could theoretically be a distortion insofar as all the shareholders receive dividends and they're in competition with each other and they've got that pot of money to do something in that market. But that doesn't apply for a public authority that can't invest as a commercial operation in a market.
No, and as you've seen from the FTT, it didn't go any further. It just stopped higher profit. That's enough. That's enough to conclude a distortion of competition. My lord, you were right. There's lots of possibility and permutations for private operators and public authorities as to what could happen to that higher profit. You need to find out. You need to carry out an analysis, is my submission. But the Upper Tribunal doesn't. In 107, it says...
It is because it is.
It is because...
I think, and then in the last sentence, the public authority could show it wasn't. So that's shifting the burden.
It is shifting the burden, and without telling me what I have to prove. I mean, that's the bit that sort of really concerns me, is that if I have another public authority come and ask me, well, what do we need to prove to show that this particular treatment wouldn't result in a distortion of competition? My respectful submission is, based on this, I wouldn't be able to tell them, because the higher profit of itself is a distortion of competition. The lower price is of itself a distortion of competition. Those are the only two possibilities. What can you prove? 108 rules out inquiries into decision making. With respect, well, first of all, that's exactly what happened in Isle of Wight. To say that's the wrong approach is inconsistent with Isle of Wight. It's one thing to say Isle of Wight is not an exhaustive test. It's another to say implicitly, as it does here, that was the wrong approach, because they definitely did consider alternative decision making in the hypothetical world. And the Court of Appeals never said don't consider decision making. In fact, in relation to potential competition and saying that a theoretical possibility is not enough, by definition you have to consider what the potential competitors will do by way of decision making. Will somebody be dissuaded in real life from entering the market because your suppliers are not taxable? That must involve assessing their decision making. So the idea that you can't look at potential decision making is with respect, wrong. It's not supported by the case law. The fact that you don't do it at I'm going very fast. The fact that you don't do it at a hyper-local level, you do it at a national level, doesn't remove the need to do it at all. The same point really comes out of 109, that there's no need to consider future decisions, but as I said, I honestly can't understand how you can consider whether there's a distortion of competition without considering future decisions.
And there it said also one engages in a fairly high degree of abstraction rather than conducting a detailed competition investigation of the sort that might be embarked upon by the competition authorities. And you would say that is wrong, would you?
It's not the same as what the competition authorities would do, because they have to be specific, I understand, about the market in terms of scope. And we're told here it's the national overall market. So to that extent, it's different. But once you get past that and you've got the market, then the strain of the principle is to carry out that assessment of, well, would the situation pertaining in that market be different with and without taxation? And that, I can't see how you can avoid that with any sensible approach to what distortion of competition means. So I accept it's not exactly the same as what the competition authorities would do, to the extent the market is at an overall level. But beyond that, assessing what distortion of competition is, it's the same principle, because those are not special principles developed for that particular purpose. Those are just how you would establish what is and is not a distortion of
If you
competition.
did apply a fairly high level, quote, a fairly high degree of abstraction, I'm not so certain where that would take you when you start to think about the facts, because you're talking about a maximum of a 20% reduction. So it could be anything between 0 and 20. And then you've got to say, at a high level of abstraction, how price sensitive are consumers? And I suspect the difference between £1 or £1.50 or £2 over a couple of hours wouldn't affect anybody, or very, very few.
But you're also not allowed to consider future decision making.
Well, I know, but at a high level abstraction, it's not obvious
Yeah,
that a reduction, the maximum of which per hour is
yeah.
20%, is going to have an effect. I mean, it's not obvious. It might, it conceivably.
Certainly, if the car, unless the car parks are side by side, then you might think, well, that one's 20% cheaper. I'll go for that.
And they've got surplus capacity. So
And they've got capacity. Yeah.
So how many spaces are there in the
Yeah.
hospital car park, which is then going to, because that controls the amount of switching that can occur on the basis of the price reduction.
Yes. Yes.
And it's got to be significant.
It has to be significant, which means more than negligible. So that's what the professor said in Isle of Wight. But
I mean,
still has
if
to
it's
be
the same
something.
as sort of the EU treaty, it means more than de minimis. But that's not negligible, it's not nothing. It's got to be material, something which is likely to have an impact on competition in a significant way.
yes, and the point of this is, does it disadvantage private operators? And if you don't demonstrate that customers are likely to shift their custom from private operators' car park to NHS car park, who's disadvantaged? So it does go back to the purpose.
Do we have any? I mean, what was the case? I saw in the case about local authority and private car parks, there's about 16,000 car parks in the country. I think it was 11,500 and 5,000 odd. Do we know how many hospital car parks there are in the country? Finger in the air? How many hospitals?
240 trusts, each one's got 2 car parks.
Okay, so 500 odd-ish. So we're talking, I mean, I'm just, absolute finger in the air stuff, it's 500 against about 15,000. So we're talking about the total maximum capacity, which would come available as a result of a reduction in price in 500 to 1,000 car parks, as against the other
And
15,000.
NHS car parks are situated to be convenient to access the hospital,
Of course.
whereas private operators,
Exactly.
they choose the plum spots where they think people are
Yeah.
going to want to park there. It's a different
Yeah.
it's a different model.
Okay, that's high level of abstraction, but you say it's a high level of detail that's required. An
Enough
appropriate
detail to be able to make an assessment of the basic question. Yeah, I mean, we can see at 119 that this really does amount to a presumption, because that's a reference to the Loughborough decision, which was also Judge Sinfield. And at 122, you can see that they say it's for us to rebut on the facts of the individual case, which again, given that we don't bear the burden of proof, is a rather surprising situation to be in. It's made more surprising and difficult by the fact that reading this, I do not know what facts we would have to prove, because the higher profit is a distortion of competition, the lower price is a distortion of competition. Between those two possibilities, what could I possibly try to prove on behalf of an NHS trust? And this really, that is said in the context of my submission that, well, HMRC have no evidence to support a finding of a significant distortion of competition. It's because of the test the Upper Tribunal applies that actually you don't really need evidence. You do it at a high level of abstraction, and that's why HMRC were able to survive that ground of appeal. I will briefly run through my errors. I think you've already got them, to be honest. Error number 1, accepting that higher profits of itself was or produced a distortion of competition. Error number 2 is failing to apply the correct test, which is to consider the effect pertaining in the market. Error number 3, adopting a test that, in my submission, is impossible to satisfy. Error number 4, deciding that the consequences in terms of decision making could not be taken into account. And error number 5 is failing to decide what would actually happen. That point might be worth just showing you. So paragraph 111. The Upper Tribunal says, well, we don't agree that the Trust is required to insure its charges for the same or higher than local car parks. The guidance that we've described at 13 simply states that NHS sites that are close to city town centres may need to ensure their car parking charges are not lower to discourage commuters, provides no sufficient basis for finding that there would be no distortion of competition. But actually what the Upper Tribunal, I don't accept that. You've heard my submissions on the guidance, you've seen the guidance, but that's the opposite way around. There needs to be a finding that there would be a sufficient distortion of competition, which means that you would need to be able to find that they would lower their prices. And you've got here quite good evidence suggesting they wouldn't be allowed to. So the error there is failing to identify and decide what would happen, which is the same error the FTT makes. It just says, well, one of these things will happen, that's enough. Significant distortion of competition. So now on the significance point, I've got 3 points. They're only short. First, in my submission, it's impossible to assess whether distortion is significant unless you identify what it is. And neither the FTT or the Upper Tribunal did that. Significance, there's a second point, significance must surely be concerned with the impact on competitors or potential competitors, and therefore requires an assessment of that impact, which again we don't see in either the Upper Chair or the FTT. And the third is that the Upper Tribunal's approach and the FTT's approach renders this requirement that the distortion be significant meaningless. The decision based solely on the quantum of VAT will always be satisfied. Just as an additional point on that, I do refer to the National Roads Authority case, which refers to the principle of effectiveness, in the sense of saying that yes, we must interpret this strictly, but not so that it deprives of its purpose. And if you end up with a situation where the interpretation or approach to Article 13 is such that the public authority cannot, in practice, satisfy it, or it's excessively difficult, that breaches the principle of effectiveness in EU law. Finally, my no evidence point is a point I've already made, which is there was no evidence. I mean, the Upper Tribunal asked Mr. Watkinson, I know a friend joined the hearing, what evidence do you rely on? And as far as I can recollect, the only thing pointed to was the example of the airport car park the airport users using the NHS car park until the prices were increased. That was it, as I understood it. And his skeleton argument doesn't identify any additional evidence. But this is a function of the test applied. If it's the abstract test applied by the FTT and the Tribunal, which really starts with a presumption, he didn't need evidence. But on my approach, he did need evidence, and HMRC didn't have it. And therefore, the finding is unevidenced. So it might not add anything much to what I've already said. If I may just turn my back for one moment, that hopefully completes. I'm very grateful for the court's attention. That's the submission for the event.
Thank you very much. And within time, Mr. Watkinson.
Thank you, my lady. Can I begin where the court began, please, with the guidance itself, just to pick up on a couple of points. So those are the key document relied on is within your supplemental bundle, beginning at page 154. And I return to a point my Lady Justice Falk picked up on in relation to contracting out. What one sees at the top of page 155 is the guidance envisaging the car parking being contracted out to a private operator. And thereafter, within the footnotes, footnote 5 envisages commuters using the car parks as a matter of generality. And footnote 6 envisages private operators being members of one of the two trade associations. And so one asks oneself in relation to this guidance, where the car parking is contracted out to a private operator, do the principles in the guidance apply? If yes, then prima facie one has a private operator subject to the same conditions, apparently, in my own friend's case, as the public authority. So the fundamental requirement of an SLR, special legal regime, being application of two different sets of conditions, appears rather to evaporate. The counterfactual to that: what if they don't apply to a private operator? Then public authority can simply abrogate what apparently are conditions amounting to conditions of law by subcontracting the function to a private operator.
So is your point that subcontractors are or are not subject to the principles?
I don't know the answer, so I'm posing the only two answers. And answer one is they do apply, in which case they apply to a private operator.
Well,
Answer two is they don't apply.
First sentence says NHS organisations are responsible for the actions of private contractors who run car parks on their behalf.
Yeah.
Doesn't that suggest that the Department of Health treats them as subject to the same principles?
It may do, and if it does treat them as subject to the same principles, then there are private operators in the market subject to the same conditions as public authorities.
but via a totally different route, surely. I mean,
It's via a totally different route.
the private operator is clearly can't be the subject to judicial review proceedings.
No, and it's
if you take that sentence in the most obvious way, it would suggest that NHS organisations are expected to impose provisions in their contractual arrangements that ensure compliance, which would be a very different route.
and it would result still in the operator, if it's acting under the same principles, not having the exemption, but still being subject to the principles. Or one can consider, if it didn't apply, then a public authority is able to move away from that guidance simply by subcontracting.
At the top of page 155, the second sentence suggests that they are, in the sense that the NHS organisation is required to act against contractors in line with the relevant codes of practice. So the trust has to, through its contract or otherwise, control the behaviour of the contractor so that it's in line with the guidelines.
No, my lady, because the codes of practice referred to is subsection 6 of the footnotes,
okay.
which are the codes
The trade
applicable.
associations.
Yeah.
Thank you, I'm sorry.
So I don't submit that there's a clear answer in this, but it does raise fog where it's asserted that there's a special legal regime because these conditions apply only to a public authority providing its car parking, when it appears that they also either are supposed to apply to a private operator who doesn't gain the exemption, or if they don't apply, how are they such hard conditions that they amount to special legal regime? And then any private operator is encouraged to be a member of the trade association that other private operators are members of, so that the same codes apply and the same rights of appeal apply.
You could have lots of permutations, couldn't you?
Yeah.
If the land was owned by a private operator and just happened to be next to a hospital, it might be different. The land's owned by the hospital and they impose just somebody under a contract of operation to, as it were, collect the money for them, keep it tidy. Position might be different.
It might. And so there are various permutations. So I'm not seeking to invite the court to draw hard conclusions from the facts of that document, because we don't know, in fact, whether it applies to the private operator or not. But it does show a clear overlap in my submission between public and private operation. And that is not what one expects to see for a special legal regime based on conditions.
So is your point that because it's possible to insert private operators into the scheme of operation, that points against it being a special legal regime?
No, not merely because one can insert the private operators, but if one does insert those private operators, they appear to be subject to the same types of condition that are said to generate the special legal regime when the public authority is undertaking the same activity. As to general statutory source, we were not able to identify statutory source for the guidance that the appellant relied upon. Can I take you to the Upper Tribunal's decision, please, in the core bundle at page 75. This deals with the Upper Tribunal's decision not to permit the appellant to rely after the hearing on a new matrix of statutory constraint. Paragraph 63 sets out how the respondents had requested particulars of the precise statutory basis on which the trust asserted a special legal regime. What was identified was simply Section 9 of the NHS Act 2006, but on appeal even that limited point had not been pursued by the trust, and so the proposition being put forward by the appellant was the wider proposition that guidance, whatever its source, plus the obligation in public law to have regard to it, equates to the special legal regime.
Yeah, it's a slightly different point though, because what the Upper Tribunal is recording is you objected to the trust case on statutory constraints being a change of case, but this is a slightly different question, which is the source of this guidance.
I fully accept that, my lady.
Yeah.
That's why I've taken you to paragraph 63, which is because from the outset of the proceedings, the the respondents have been asking where one can trace this regime to in the statute.
Well, no one is doubting, or no one has questioned the standing of the Department of Health to issue the guidance that it has.
No, and what one can't identify with precision, or that I've not been able to identify, is any particular power or purpose to that. So in the NHS Act 2006, one sees requirements for guidance to be issued by various bodies for various things under various powers, and we were not able to trace that kind of guidance back to something specific. So nothing like a code of practice or statutory guidance issued across various fields of law.
There's a lot of references to a lot of subordinate legislation in tab 9, which is the DOH Health Technical Memorandum in relation to car parking, environment and sustainability. And we haven't had a chance to dig down into them.
But briefly canvassing those whilst my learned friend was on his feet, I couldn't find an obvious source. So there is the diagram, but that's really it. So that's why the argument before the Upper Tribunal effectively proceeded on the basis of the proposition that guidance plus the public or law obligation equates to special legal regime.
But the DOH appears to be issuing principles for nearly 20 years, about 2006, I think I've seen the first reference. I'm not certain we've got that copy of...
No, I think we have the 2015.
We've got the 2015, but not the earlier one.
I think I've seen references even further back than that, to 1998 or so. But maybe wrong.
Well, we've set Mr. Firth some homework, and it actually would be useful if you can all put your heads together and come up with what you think are the relevant sources. I know doing it on the hoof is not satisfactory.
Yes, and I'll continue to look, but that's how we ended up with the position that was before the Upper Tribunal.
You could ask the Department of Health.
You could.
So that's where we were in terms of tracing the powers back. In terms of background principles, there are two in my submission that are of importance before one gets to Article 13.1 and the principles that apply to that. The first of which is legal certainty.
We've arrived at 4:15. I don't want to stop you necessarily, especially as we've had the experience we have. You'll have only had 15 minutes of your allotted time. Your allotted time was meant to start at 3.
Yes.
How long were you meant to have tomorrow before Mr. Firth replied?
I think my learned friend was hoping for about half an hour.
Okay, so you were going to get an hour and a quarter and 2 hours. So you're going to get 3 1/4 hours. So you've got on the clock. You have 3 hours still to run, which is obviously takes us beyond lunchtime tomorrow, and then we have a half an hour. I'm willing to continue for a little longer now, and if necessary, of course, I think certainly we are available tomorrow after the short adjournment. But if it were possible, one way or another, to deal with this matter during the morning tomorrow, that will perhaps be more convenient for everyone. But I'm in no way trying to constrain you, because it's none of our faults that we spent quite a lot of time outside today. Right. So on this basis, having wasted all that time, I'm going to ask you to continue until 4:30.
Thank you.
And as Lord Justice Green pointed out, if it will help, we will start at 10:15 tomorrow.
I'm grateful, and I will cut my cloth accordingly in any event.
But as I say, Mr. Watkinson, I'm not in any way trying to limit you in that way.
I'm grateful, madam. So the first principle of broad application is that of legal certainty, and one finds that in Isle of Wight in the CJEU, please. That's your bundle 3 at page 797. And the court makes their first reference to principles of legal certainty, I think paragraph 41, and then picks that up over the page, please, 798, paragraph 47 and 48, if I can invite you to read that quickly. So legal certainty is a fundamental principle of the operation of the VAT system, and when one comes on later to the human rights authorities that have considered whether the need for legal certainty applies, one has the same need for legal certainty in relation to the VAT system.
Can I just ask you in this context, what the court was here is rejecting on grounds of legal certainty is an argument that only certain local authorities will be subject to tax to the exclusion of others. That's 45 lines 1 and 2. And the principle of legal certainty applies by ensuring that all bodies are either taxable or non-taxable. That is consistent with legal certainty.
Yes.
So an argument, even if the government had to change it, let's say every 3 or 5 years because the market changed, then everybody is subject to the same rule, public authorities, NHS trusts. On the facts and the context here, does it help you?
It helps me insofar as when one is looking at whether the guidance is a legal condition, whether it provides sufficient certainty to those involved, whether their transaction takes place as a taxable person or not.
I see.
My submission will be that if you have what I will term soft guidance, that does not fulfil that condition. And if it's bad for legal certainty, then that suggests the consequences of it are incorrect.
So you're not saying that if a global decision were taken across the whole of the nation, that would itself...
No, because the competition analysis, as we've identified, has to be undertaken on the hypothetical national market level as opposed to local.
Yeah, that's helpful, thank you.
The second principle then is that of the objective character of a transaction being primarily determinative of its VAT liability. For that, one goes into BLP in the CJEU, please. The relevant paragraph is at page 680. I'm afraid that's in bundle 2 of the authorities. page 680, paragraph 24, please. To the effect that inquiries to determine the intention of a taxable person are contrary to the VAT system's objectives of ensuring legal certainty and facilitating application of the tax by having regard, save in exceptional cases, to the objective character of the transaction in question.
And so that's the basis, is it, for saying we haven't got to inquire whether it's intended to use the profits for scanners or whether it's intended to reduce the price?
Or indeed what the intentions of the public authority are more broadly, but also to reflect that their intention is not what should drive the analysis of the VAT liability. So their choices. So those are two of the fundamental conditions that apply. And then one can move to the conditions and principles that my learned friends laid out. The first of which is the purpose of the exemption.
Well, it's a derogation strictly, isn't it?
Yes. So the purpose of making the person non-taxable. We know it can't be a public interest condition because there are other parts of the Principal VAT Directive that specifically provide for public interest exemptions or derogations. You've seen that in Carpagneto Piacentino, paragraphs 13 to 14. That's Article 132. And the reason it's not an exemption but a derogation is that it's not just an effect on the outputs. So it's not just I'm a public authority, therefore I don't charge VAT. So I'm a public authority, so I also can't reclaim any VAT on the inputs. So simply looking at the outputs and saying there should be some benefit to me in terms of income, in my submission, misses the other end of the supply chain, which means you can't reclaim any inputs.
What does this go to in terms of the definition of the exempt service? Does this?
It goes to the purpose.
But what does, in your submission, what does purpose go to? Is it governed by, or is it the word as?
Forgive me, is...
This, I'm just looking at 24.
Yes.
Where the court is saying it's, if it were otherwise, the authorities would have to examine the intention of the taxable person, so each individual person. And I'm just wondering how that fits into the definition or the analysis we've got to apply to the exemption.
So it fits into whether any intention of the public authority goes to whether it meets the terms of the derogation.
But it may be helpful to explain that what BLP is about. It's about use of inputs to make outputs. So the context of the reference to intention is you don't look at what the individual taxpayer was intending. You need to bear that. I understand that there's a general point at the end of 24, but that context is also important to understand what 24 is saying.
Yes, I accept that, but it's the more general point that I rely on as to whether the intention of the public authority can impact upon whether it in fact falls within the derogation.
So what aspects of the test that we're applying would involve an analysis of intention?
So if on the first major limb, so acting as a public authority, if that is pinned to what I intend to do with the money, what I'm intending to do in terms of that going back into the health system, etc. In my submission, those are not appropriate for determining whether the derogation is met.
The
Because it's
guidelines
not.
we've seen suggest that the money must go back for NHS purposes in broad terms. That's not intention, that's just a limitation on the use of money.
Well, it's the intention of the person who's written the guidance, and that's the guidance that's said to apply. And if you were the public authority who'd written it yourself, you're subject to the same administrative law principle, which is you should follow your own guidance unless there's a good reason not to.
We can't take account of the intention of the government, the Department of Health.
No.
We can't.
Not for the purposes of this derogation. One's simply looking whether one's acting as a public authority on that second limb. And it may be that one derives from the statute or a national law condition that you're given a power for a certain reason and you then go and undertake that activity. But once you get to the point of being able to, for example, self-author guidance that determines your...
It's not the trust self-authoring it, it's government which is subject to broad statutory, parliamentary, public law duties.
No, I accept that in this case, but the broader point is if a public authority is subject to the same administrative law principle in respect of its own guidance, why does one have to draw a line between the two?
Because of mutability. We know from the facts that the public law guidance has arisen well over 20 years, almost a quarter of a century. Whereas you're right that if you could mark your own homework by generating internally something which facilitated you getting a tax exemption, then I think the law might very well analyse it differently. But this is an external body tasked with ensuring that the broad principles of the national health are adhered to.
But in my submission, it hinges on the same principle, which is a public law body is subject to the obligation to follow guidance unless there's a good reason not to. And it applies as much to internal guidance or policy as external guidance and policy, save for specific statutory guidance. So as a matter of principle, when one looks at it, that justifies self-authorship. That justifies my intention being, I will write a policy and I will say that impacts on my car parking, and therefore I fall within the derogation.
But where does this go? Does this go to your legal certainty point or another point?
It goes to legal certainty. It goes to the fundamental principle that I would submit is that it's the legislature who determines who is taxable as a person, or the scope of the way the tax is normally supposed to be applied. And yes, you can choose between a variety of transactions, BLP type, as to whether you want to enter into an exempt transaction or not, but it's not generally, or I don't think in my submission that there is another example of where a potentially taxable person or taxable person could write their own status, save for VAT registration.
It's not a status. I mean, you're taxed on transactions. Everyone, generally, and people decide whether to enter into transactions or not, or in what form, and that can very well fundamentally alter the tax treatment.
Yes, but that's
the
decided.
The relevant legislation is the VAT legislation.
Yeah.
And that tells us the test is either is governance and as. So I think your analysis has to go to this, that in no circumstances can guidance ever be sufficient to meet the test of either governance or acting as in the relevant provision. It really means that the line of cases in Munaz and others are just irrelevant.
No, it means that guidance in the context of VAT cannot amount, guidance plus the public law obligation to have regard to it cannot amount to a special legal regime. That is the submission.
Yeah. And that comes from paragraph 24. Anything else? Is that your only source for this principle?
No, And tomorrow, I note the time, we'll come on to the cases that,
Mr. Firth was hoping you'd say yes, of course.
that discuss that, but no, that's not really.
Okay, but that's the divide, isn't it?
Yeah.
I mean, really, you're taking an entirely different view of how the statutory provision should be applied. I mean, you're either right, both of you are either right or you're wrong.
Yeah, that's it. And the fundamental submission is guidance of this nature does not amount to
It
an
doesn't add up. It
SLR.
has no probative value at all.
It has no legal value in creating a condition, national law condition, that provides a special legal regime.
Okay.
And that is really the main dividing line.
It is, yeah.
Thank you very much indeed. As you'll note, we'll say that you've had half an hour rather than 35 minutes.
I'm grateful.
From your agreed slot. I'm sure you will discuss that with Mr. Firth. Thank you very much to both of you and to everyone behind you. And we will sit at 10:15 tomorrow.
So you set up a cliffhanger. Everyone will be there tomorrow now. How do you think you'll do tomorrow morning? We will then, yeah.
I'm going to cut it down as much as I can overnight,
Okay.
with the aim of leaving you. Okay, thank you
Lovely.
very much.
Thank you very much. Oh, Howard, just to mention, I'm going to bring a case called Frank A. Smart in the Supreme Court, which looks at BLP and that
Yeah.
point about.
Can you just email me one?
I'll send it tonight. Yeah. Are you all right? Will you be able to print off a case if I send it around?
Maybe, yeah, no problem.
Well, we
We'll
should be,
need-
we
we'll
should
need
be.
the three copies.
Well, actually, yeah. Email them.
If not, I can get Jimmy to do it down and just.
No, well, we can get it done in the morning, I'm sure.
Okay.
Email it.
If you can get it done with ease, that's not a straight.
Well, no, because I don't go to gym, but I come straight here. Actually, let me.
I mean, we'll just go.
If you
I've
need
got
it,
a printer at home.
I mean, we'll have to go to Ryman's and do it.
Yeah, I only need 3 copies. I'll use it digitally. I'll send it. It'll be fine. Don't worry.
yeah.
Yeah, you have to buy this separately. My parents bought it for me.
Very proud parents indeed.
Should have quick debrief that side. Going on merry ways.
Are you Helen, sorry?
I am.
Oh, I'm Noel, we've been emailing
Oh,
with each other,
okay.
yeah. David there. Right. Exactly, yeah, you've been involved. Excellent.
Just to see your name spelled right.
Yeah, face to a name and all that.
Oh no, it wasn't the last time. I think before.
You think we'll change it to Kellen?